Yeah, my name is Mathias Marcussen. I'm originally a lawyer from Denmark. So I'm now in the Mechanism for International Criminal Tribunals, where I am the senior legal officer and officer in charge of the Hague Branch of the Office of the Prosecutor there, under Prosecutor Sas Brammertz.
Were you destined? Here we go. Oh. We'll edit that out. Were you destined to be a lawyer?
I don't think so. No. I ended up studying law, but maybe my interest was very much from the early stage at the sort of on the international aspects. So a little strange for a Danish lawyer. I did a lot of public international law while I studied.
Yep.
And when I did that, it was at a time when international humanitarian law started to. There was a buzz. There were things happening, so I took an interest in that. And then the Yugoslavia and Rwanda tribunals were being created right around that time that I finished. So I followed that very closely. Actually, so closely that I wrote on my final thesis on prosecution of war criminals and thought I have set myself on a path for unemployment because of the rather peculiar thing I'd done to myself there. I did get a job in the Danish Ministry of Environment, of all places, which was a bit odd. But quite soon after, I was asked by the Danish Foreign Office, or Ministry of Foreign Affairs, if I was interested in a secondment to the Rwanda Tribunal for 6 months to help set up their legal section in the Office of the Prosecutor there. So
you worked with Hassan Jallow at the time?
It was way before that. I actually started around the same time as Abour did.
Pardon?
When Judge Abour became prosecutor. Yeah, Louis. So yeah, back then, and Rakutomanana Rakutomanana was the deputy prosecutor in Kigali at the time. It was before the Arusha office was really set up, so we were at the headquarters in Hotel Amahoro in Kigali.
Wow.
So interesting times.
Well, how interesting was it? I mean, this is out of whole cloth. You're making up a tribunal which was created shortly after the Yugoslavia tribunal.
Yes.
It was Yugoslavia and then Rwanda.
Yeah.
Did you know much about what you were buying into when you ended up setting yourself up there?
No. No, I don't think so. I mean, it was novel. It was novel in many ways. Of course, there had been the Nuremberg tribunals. There had been a few cases afterwards, but we were breaking new ground. And of course, the Yugoslav tribunal had started a little before the Rwanda tribunal. But I think all of us really felt we were breaking new ground. Not that we were so conscious about it, but it became very apparent every time we had a real practical legal question that there weren't that many sources, there wasn't that much material to work with, and so in trying to apply customary international law, there were a lot of unanswered questions. And when I look back now at the kind of questions we dealt with, they feel like extraordinarily big picture type questions compared to where we're at now, where we're really down into very detailed questions. And then I think we did make up something. We namely made up international criminal procedural law, which really didn't exist. And that was the other thing, that there were so many practical and legal questions on the procedural side. It's quite amazing to think about how it looked then and how it is now.
Did you look back to Nuremberg? Did you paw through the procedures and the transcripts to help you at all factor in?
We tried, but I mean, it sounds crazy, but in the beginning in Kigali, when I went down actually in '96, I was advised by another Dane who had been sent down to go through The Hague and meet colleagues there, just to be briefed about what was going on and things, and I was encouraged to go to Youngblood, which at that time was a very well-supplied legal bookshop in The Hague, and buy all the books I could because there was not a library in Kigali, so I did. And that gave me about 80 centimeters of books, and they were not so useful because it wasn't so practical. But we actually didn't have copies of the Nuremberg materials in the beginning. Yep. So we got that much later, but of course it was an important source for us to work with. But the Genocide Convention came after the Nuremberg judgments, right. And so in Rwanda the Genocide Convention was of course particularly important. So yes, we looked to those cases, but I think we felt they didn't help us so much.
Right. Now the Rwanda Tribunal was really the first one of those post-Nuremberg tribunals to allege genocide, as I recall.
Yes.
I don't think Yugoslavia.
Yeah, I mean, yes, of course it's in the statute of the Yugoslavia Tribunal as well, but really it was the Rwanda Tribunal that first really charged genocide and actually did genocide cases. And of course the Yugoslav side, where it has ended up, has been really, there have only been genocide convictions in relation to Srebrenica, whereas all the Rwanda cases have included genocide. So I wouldn't say the ICTR was a genocide tribunal, but it is, I think it's fair to say it was the most important crime that was prosecuted there.
How long were you there?
I was in Kigali for 3.5, 4 years.
What was it like? I mean, here you are, coming from a Scandinavian country, all of a sudden there, Kigali.
It was fascinating, of course, and very strange. Coming from Denmark, a peaceful country, and walking into the office, and there were still sandbags in protecting the stairways that we went up through to the office, and so just the work environment was an interesting one. For me, it was my first experience in Africa, so that was very interesting. And then I think there was something very important actually in the ICTR being in the place where the crimes were committed. Of course, relations with the Rwandan government were not so easy, and that really filtered through. It was difficult to really interact, I found, with Rwandans at the time. But of course, we all got friends and acquaintances, and when you live where the crimes were committed, and you have colleagues who have lived through the genocide, or genocide survivors, or people who have returned afterwards, it is a constant reminder of why you were there, and I think that was very healthy to actually be there on the ground. And everybody who do this work, of course, I think recognize the importance of what victims have suffered, and but living in the middle of the whole thing was impressive. It really was.
So you're explaining this to your family members back in Denmark about you've been gone, you will be there for 4 years. How do you explain it to them what you're doing?
Yeah, that's difficult, and I thought I was only be there for 6 months. So when I explained them where I was going, I would say I'll be back soon. But no, I mean, people of course knew about the genocide, and in a way, it's not so difficult to explain. I mean, you explain about the crimes. People are normally very curious. I think what's difficult to explain or was difficult at the time to explain to people was, I think it was a notion, a lot of people thought, well, you can't do that without that kind of work, without it being extraordinarily difficult and traumatizing at a personal level and that kind of thing. And I don't know. I think far most of us had a quite professional approach to it, which was what enabled us to get through. Maybe we had the filters in place. But I think the question that I got the most, where people had difficulties understanding what it all was about, was this aspect of how can you do it?
Emotionally?
Yeah.
Yeah.
Yeah. But I think we could, and it. And again, living in Rwanda help you focus attention. You also see that life goes on and things. But
the actual defendants themselves, did you have a hard time arresting them and getting them under control, custody? Is that a hard thing?
What do you mean, finding them?
Yeah.
Well, actually, for the Rwanda Tribunal, it was kind of an interesting situation, because at a very early stage, and a number of countries, mainly in Africa, had arrested people who were indicted or were suspected, and we were working on cases. And all of a sudden, we were informed that there had been arrests in various countries, and would we be able to, did we want these people or not? And if the answer was no, then they would be extradited from the country, or so initially there was an influx of cases, and they were nearly too easy to get, because it really meant there was a lot of work to get indictments out. So on the one hand, there were some cases that came nearly too easily, or the timing was a bit put us on pressure. And then, of course, there were other people who evaded justice and are still evading justice and have been extremely difficult to get. And so we have had these tracking teams that have been trying to locate fugitives. With a lot of success, but it is a very difficult process, and as I'm sure you know, yes, Kabuga, one of the important fugitives, was arrested in Paris in May of 2020. A very high-profile accused, one of the he belonged up in the category of masterminds of the genocide, and always featured very prominently when people talk about the genocide. He was being tracked for 20 years, and eventually he was located in Paris and arrested, and in precisely a month, or in a month and a day, we will have opening statements in his trial. So, the time it took to locate him and get him arrested says something about how difficult it is.
Yeah.
And then there are still some fugitives that are being tracked, so it is not finished business yet.
I found that article, ironically, just yesterday. I thought I'd just throw it in here. Little did I realize we'd be talking about it. When you say the opening statements are coming out soon, is this the residual Rwanda tribunal that picks up the jurisdiction here? Yeah,
so what happened is it was decided that the Yugoslavia and the Rwanda tribunals should complete their work. And there are a lot of people that think, and I think we ourselves also initially thought about the tribunals as being courts, which of course we are. But really we are, the establishment of the tribunals is really the establishment of, to a large extent, the whole judicial system. And I don't think anybody, when the tribunals were established, thought about all the things that entail, but that entails sentencing enforcement, that entails witness protection, that entails management of evidence. So there are a lot of functions that are not over once the cases are over. And then there was a decision to create this International Residual Mechanism to have those continuing functions after proceedings were over at the tribunals. The only problem was proceedings were not over on time, and there were still fugitives. And as a consequence, the mechanism has been conducting a number of cases. Actually, from the very beginning, there was the India Batwari case where there had been a trial judgment from the ICTR, but the actual appeal was at the mechanism. We have had a retrial ordered in a case called Stanisic and Samatovic against two high-level Serb security state officials, or security service officials. So the head of the Serbian State Security Service, Stanisic, was acquitted by the ICTY. We won the appeal in the case, and the case then restarted before the mechanism, and there the appeal process is about to finish. So we have had those cases, and we've had a number of contempt cases, and there have been various judicial action which wasn't expected, I think, initially, but that was just how the mechanism ended up doing cases. But there were always these fugitives, and there were at the time the ICTR closed, there were 9 fugitives that hadn't been apprehended. 3 of them were to be tried by the mechanism, and the 6 others, if apprehended, the cases had been transferred to Rwanda, so Rwanda should try them. Kabuga was one of the 3. The 2 other ones are dead. So this spring we announced that Piranha died many years ago, it turned out. So that actually concludes the fugitive that will be tried by the mechanism. There's still, we also announced the death of another fugitive, but there are 4 left that are still being tracked, where we are still active, although the cases will be most likely tried in Rwanda. One of them, Kaishima, we believe is in Southern Africa. So there we have one of those situations of trying to get the national support that's needed to actually ensure an arrest. And the other ones we're also looking for.
But when you say we, you're actively involved in this, right?
I'm not actually involved in the tracking. I am the head of the Hague Branch of the mechanism, so I'm responsible for the ongoing case work. We have a lot of for the ongoing work. So what we normally have is, for cases we designate a trial team or an appeals team. So there are teams doing that, the day-to-day work. I do a lot of, and we have a team that does tracking. We have a number of other, as I said, a number of other residual functions. I think one of the very important ones is that we have of course done a lot of cases. In the process, we have accumulated a lot of evidence. So we have a total of about 10 million pages of evidence, and 9 million pages of those come from the Yugoslav investigations. We have tens of thousands of artifacts and video and audio tapes and all sorts of things. And a lot of that material have never been used in any cases. At the same time, we were never intended to try all cases, and there are many perpetrators out there still, and there are many countries, fortunately, who are still trying to bring justice to victims. And so we share our evidence with national authorities. We get about 400 requests a year at the moment for assistance, requests for evidence that come in from law enforcement or prosecutors in various countries. So that's a very important aspect of our work. We also, together with the ICRC, have a project where we use this evidence to try to locate or at least find out what happened to the more than 10,000 victims who have never been found after the wars in the former Yugoslavia. So that's another quite big project. So we basically search name by name through our evidence and see what we can find and contribute, and share that information with the ICRC that also have other partners. And all of that will hopefully lead to we can find out what happened to people, either locate graves, or at least be able to share with families what is known, what can be said about what happened, or when are people last seen, or that comes to help bring closure to the victims. And then we do capacity building training, these kind of things, to try to pass on the knowledge and know-how we have built up over the 3 decades, I guess, that we have been operating.
It's a curiosity. We've talked about that here over the past many events. Best practices.
Yes.
And at this point, you have these tribunals that are active, ICTY, ICTR. You got Cambodia winding up. You got Sierra Leone that's winding up. Again, with these residual mechanisms. But the question was, what we learned, will that ever be cataloged, if you will, best practices? Do you get a sense of that?
I mean, there have been efforts made from the ICTY and mechanism side. There's best practices on prosecution of sexual violence cases. I think that was a very comprehensive project and really quite detailed analysis of best practice, and I think quite honest assessments also of what didn't work, which I think is an important thing also to capture when you do best practices. So been that, we're trying to also do other things. It's resource demanding, but I think it's important, and I think it's important to. We often focus on law and the legal aspects. I think it's important to create awareness also of how to use our jurisprudence at a more practical level. So one thing is you can read, the elements of crimes and modes of liability and those kind of things. But our jurisprudence have also, of course, covered a broad range of factual scenarios, and our judgments give insight into how you can prove a broad range of crimes. So I also think it's important for practitioners and for us to create awareness among practitioners of maybe other ways or other practical ways of reading our jurisprudence beyond just looking at the law. So that's something we also try to do when we do our capacity buildings, try to help shift from just focusing on legal issues and shift to training that focus more on practical aspects and how you can get inspiration from our cases. And I think that is very important, because ultimately you have to apply the law to your specific facts, and it can be overwhelming and difficult and time consuming. So yeah, seeing how others have done it and what you can learn, and what evidence, what judges have said about how they have evaluated evidence is important. It's easier for everybody to do something if others have done it, and so being able to share that, look, this is how this type of evidence have been assessed by the ICTR, the ICTY, I think is helpful tools for other people who prosecute these kind of cases.
We got you 4 years in the Rwanda tribunal.
Yep.
Let's continue your life arc. What after that, then what?
Well, so at the time, there was one prosecutor for the 2 tribunals. So there was a Rwanda tribunal and there was a Yugoslav tribunal, but there was one prosecutor for both tribunals, and there was one appeals chamber. So when the first trials were over, so the Akayesu case and the Kambanda case, it was a guilty plea, but the Rwandan prime minister during the genocide pled guilty. When those 2 cases came on appeal, the decision was that the team that would do the appeal would be the appeals section of the Office of the Prosecutor that was in The Hague. And then I was asked to go to The Hague for 6 months to bring the cases up and be the person with knowledge from Rwanda to help to work with the appeals team on those appeals. And then Then came the next judgment and the next judgment and the next judgment. So I ended up working for quite some time on Rwanda-related appeals, but being in The Hague. And eventually I converted over to actually moved from the ICTR to the ICTY. So I did appeals for some years. And then having done appeals for a period of time, I felt like a change. So I moved over and worked with trial teams. So I worked on a number of our trials and eventually became senior trial attorney on one of our cases, and then was back as senior appeals counsel for a bit.
What tribunal were you then at?
That was at the Yugoslav tribunal. Yugoslav tribunal, yes. And then when
you're working with Serge at this point, right?
Yes. So Serge became prosecutor, and then when I took up the position I have now in the mechanism. At that point in time, Hassan Jallo was prosecutor of the ICTR. He became the first mechanism prosecutor. Mm-hmm. So I worked under him, setting up the Hague Branch. So we set up in the same premises as Yugoslav Tribunal. We created a little separate office of the prosecutor for the mechanism. Although we in many ways, it felt like we were, and that's really also what we should do. We should just continue the work that had been doing. We did have another institution all of a sudden, so there is a certain amount of institutional setup that had to be done. So we did that, and then very much became mechanism prosecutor. So now I'm back under him.
As you kind of reflect, that's just like 20,
I don't know what, 20, what's that? 96 to now? Oh gosh, that's a lot, 26, yeah.
Yeah. What have you seen in the evolution of the international criminal? I mean, certain tribunals have been created since you started, Sierra Leone, Cambodia, Lebanon, among others, and the ICC, of course. Do you get a sense of kind of the ebb and flow of international criminal law?
I think ebb and flow is a very good description. Yes, I mean there was a lot of excitement when the Yugoslav and Rwanda tribunals were created, and I think thanks to the fact that we were able to actually deliver and produce cases. That excitement sort of spilled over, and I think if it hadn't been possible to do that, I don't think we would have seen the subsequent mechanisms, and I don't think the negotiations about the Rome Statute would have gone so well. So I think the tribunals were very important in that way, but actually relatively early, I think there was a sense of these are big institutions that have been created. Are we going to repeat this? And we saw various hybrid solutions, but the ICC got up and running. But I think we have seen a period of time when there is maybe less enthusiasm for international criminal justice, or at least for our tribunal, for the courts operating at the international level. And of course the pendulum have swung towards the principle of complementarity and mass prosecutions at the national levels, which I don't think is a bad thing. The international level can never try a vast number of cases, and it's also important that justice is close to where crimes were committed. So I think we're at a stage where international criminal law has been established and is a solid field. The place where it is being practiced is shifting more and more to the national level, which creates challenges in this information sharing and making sure that national prosecutors, in many cases, are tried by national prosecutors who do all sort of other normal criminal cases, and I'm not sure it's always fun for a national prosecutor who has a lot of work to do to suddenly get a war crimes case, which will take up a lot of resources. But anyway, so there's definitely maybe a less favorable view at the moment about a less appetite for international courts. But I hope that is a phase, and that enthusiasm will come back more. And I think what we have to do as practitioners is to continue to show results and demonstrate that this is possible, and be able to show that we can deliver justice and are able to do it in an expedited way.
Given what's gone on since February, of course, in Ukraine, and the call for international criminal justice against the perpetrators of alleged war crimes that are occurring there, it draws a spotlight, I would believe, on that which has occurred from tribunals in the past. Have you seen that, where all of a sudden people saying, if we would try those most responsible for what's happened in Ukraine, is there a model we would use? And have you found anybody reaching out to you, Yugoslavia, Rwanda, Sierra Leone, as a potential model?
There have been, there's of course, I think there's a number of things. First of all, there are many actors now in Ukraine dealing with Ukraine. And of course, the Ukrainians themselves are very active. And in the spirit of complementarity, it seems that they are doing what that principle would dictate. And then there's the ICC, which there's some crimes, there's some jurisdictional limitations, and there are a number of issues, but they are on the ground. There are many efforts to collect evidence, to consolidate evidence. There have been, of course, talk about whether there should also be a UN court or mechanism. I must say I'm not fully aware of where those discussions are at the moment. My impression is that that's probably not the direction that it will be going. But when these sort of things happen, people do look to us and as a model, or for good or bad, or as no, we don't want that. Look how that went, how expensive that was. So there have been, we crop up, and I also think this evidence sharing we do is also a model. It's something the Yugoslav Tribunal and the Rwanda Tribunal have been doing also for 26 years. And so some of these mechanisms, they have, and a lot of our colleagues, of course, have gone to all of these different other courts and mechanisms. But I think we're also being looked at for that aspect. Is it, how do you preserve evidence? How do you figure out how to share that kind of information? What do you do with it? How do you analyze it? So I also think, we are being looked at in different ways, both as a court, but also as sort of, are they doing some of those things they did? Can we use those? But it'll be interesting to see. And then those of us who come from an international background, we of course cannot help think, and what about all those other places where there also are crimes being committed, where there maybe is less focus at the moment, and hopefully there will also be support for justice in all these other places.
Well, here you are at Chautauqua Institution,
yes.
And your boss, many of your predecessors have been here in the past. What have they told you about this place?
I think you have created a forum that is really valuable. So first of all, they've said it's a wonderful location. It's a very generous organization that take great care of everyone. But I think these sort of fora are very important. Of course, those of us who are practitioners and have a chance to meet each other again or meet new colleagues, it is very valuable to have these opportunities to exchange views and ideas. And I hope for those who attend these events that it is an opportunity to get another kind of insight into the work we do. I think you are able to put, I don't count myself in the category of the chief prosecutors, but I think you have created a forum where you really have been able to bring together the top of the top people over many years, and I think that is very valuable to everybody in the field.
Well, we're thrilled you're here.
Today, to this week, well, I was fortunate that Prosecutor Brammertz was not able to come. He has been out doing some capacity building that he had committed to, and so he's out doing some of this practice sharing with others, and so then I was fortunate that he asked if I could come.
Perfect. Well, we're delighted you're here, and enjoy your time.
I'm sure I will. Thank you very much.
Great. Fabulous.